Hello everybody, welcome back to our SSCMA classes. So we are going to resume our law class. So today's topic is, very first topic is appointment of additional director under section 161 subsection 1. But before jumping to this topic, I want to tell you one more thing. Actually, I missed one thing in the previous session of, let me tell you, of independent director. Right? I missed that the number of minimum director in case of public company is 2 director. Is it clear? Again, I'm going to tell you the minimum number of director in case of listed public company of independent director was 1/3 of total number of director, right? But in case of public company, I forgot to mention that minimum number of director is 2 in number. Is it clear, everybody? So let's move to our today's topic, which is about section 101 subsection 1 additional director, appointment of additional director. Okay, I'll tell you one thing. If the management of company thinks that there is need of additional director in the company, in that case board of director are going to appoint the additional director under section 161 subsection 1. Okay, in general term, what happens, the member are having the power to appoint the directors of the company, right? But in this case, the board of director are having this right. Okay, so let's read. It's choice of company to appoint additional director, okay, by management. Okay, it is decided by management. Okay, can appoint in board meeting. In this case, in case of additional director, the board meeting, the additional director are appointed. Okay, and this is what I said. In general, members appoint directors. Okay, board can appoint additional director only if article of the company authorize the board. Okay, but what if the article of the company haven't authorized board to appoint additional director? In that case also, the board of director can appoint additional directors. But how so? I'll tell you. Even if board is silent, the board can follow table F. Table F authorize the board to appoint additional director. Okay, again what I said, if there is article of the company specifying that the board of director can appoint additional director when there is requirement of such in future. Okay, but what if the article is silent about such case, such appointment of additional director? In that case also, the board of director can appoint. But how? In that case, the company can go for table F, which give the power to board of director to appoint such directors in the company. Okay, so do you know they are also having the same power as other directors are having in the company. Is it clear? Yes. So what is the tenure of such directors? What is the tenure of additional director? Tenure is up to first AGM, which means the next AGM. Okay, and if AGM do not conducted, in that case the additional director have to vacate his office, which means the last date in which AGM should be held. Okay, and there is one more point again. Relaxation in appointment of additional director is done by either resolution, by circulation or board meeting. Okay, and this is what I said, the additional director has the same right, power, duties, liability as any other directors are having. Okay, so let's read the conditions and what law is saying about additional director. Under section 161 subsection 1, remember the section of additional director. Okay, appointment of additional director by board of director. Yes, what I told you, that in general term the member of the company are going to appoint the directors, right? And do you remember what I told you? The member are also having the right to remove the director of the company. Okay, Do you remember? Yes. Section 161(1) does not given any power to go to appoint additional, that if only if article of the company authorized by the board to appoint additional. What I said in law, that is saying that if there is article which specifies that the company can appoint additional director, then we can go for this. But what if the article is silent? Then the company can go for table F, which gives the same authorize to the BOD, right? Okay. Terms of office of additional director: the date of next annual general meeting or the last date on which annual general meeting should be held. If the AGM is not conducted, which the day on that particular date which was already decided by company, in that case the last date on which annual general meeting should have been held, okay, or the date of next annual general meeting. What is this next annual general meeting? Once the additional director are appointed by the company till the next AGM is going to happen, okay. So whichever is earlier, the terms of office of additional director is up to that date, okay. So what is section of additional director? Section 161 subsection 1. Let's go for the next section, okay, which is of appointment for an alternative director, right? Don't get confusion. 161 subsection 1 was of additional director, 161 subsection 2 is of alternative director, ठीक है. 161 subsection 2. Okay, let's read this. What is now alternative director? Okay, board appoint alternative director. Again, board was also appointing in case of 161 subsection 1 in case of additional director. Board is also appointing in case of alternative director, but what is the difference? What I told you, in case of additional director, if the management think there is additional need of any director in the company, in that case the BOD is going to appoint the additional director. But what about in this case? Okay, let's read out and let's find out what is the difference between these two directors. Okay, so the board is going to appoint additional alternative director under section 161 subsection 2, right? Okay, for period of 3 months or more, right? What I told you, the additional director was, right, will hold office up to next AGM or the last date of AGM, right? But in this case, alternative director are going to appoint for 3 months or more than that, okay. Alternative director will act in absence of original director. They are absent, which means from the India, which means the original director, the alternative director is going to perform on behalf of whom? Original director. Is it clear, everybody? Which means the alternative director is going to perform on the basis of whom? Original director, okay. In the absence of original director from India, which means original director is not in India, right, for around 3 months or more than 3 months, okay. Person cannot be appointed as alternative director in case of, there are 3 cases where alternative director, a person cannot be appointed as alternative director, and they are if holds any alternative directorship for any other director in the company, okay. If the person is holding a position of same alternative directorship for any other director, okay, they cannot hold the directorship for any other director in the company. Second, which hold directorship in same company, they cannot even go for holding directorship in the same company. And third, for independent director, which means hold independent directorship qualified as ID. This is independent director, ठीक है. Which means for in case of independent director, the alternative director should also be independent director. If the person for appointing for independent director is not independent director, alternative director, in that case the directorship would not be, yes, okay. The person cannot be appointed as alternative director, Okay, so there are three conditions where the person cannot appointed as alternative director. First, hold as alternative directorship for any other director, okay, or hold directorship in the same company, okay, and in case of independent director, okay. So there are three cases. Is it clear? Yes, this is clear. So power to appoint alternative director by board of director, either by article, right, or ordinary resolution is to be passed at general meeting. Alternative director will automatically ceases to be director as soon original director return back to India, right? What I said, the alternative director is going to act, right, perform on the basis of original director who left India due to some reason, okay. For example, the time duration should not be that long, that could be like 3 to, for example, let's take 6 months. I don't think so that should be go for more than that, okay, that time period, okay. Is this clear? And once the original director comes back to India, in that case the alternative director will automatically ceases to be director, okay, as soon original director return back in India. Let's go for what law is saying now. Alternative director, appointment for alternative director. The board may appoint an alternative director to act in place of director during the absence of original director from India for a period of 3 months or more, right? Next, a person cannot hold any alternative director if he already holds any alternative directorship in any other company, yes. If holds any directorship in same company, yes. And one more point of independent director, okay, independent director. Okay, next, appointment of alternative director is either by board meeting, right, or by passing resolution by circular. Is this part clear? Yes, this was simple. Okay, and let's jump to the next section, which says that appointment of director by third party. Do you remember this name? Nominee director. Section 161 subsection 3. Let's go and write it. 161 subsection 3, nominee director. Okay. Okay, so nominee directors are actually watchdogs of financial institution, okay, to safeguard their fund by in the assisted company, okay. Nominee director ensure that the condition of the loan agreement between institutional and assisted company are being complied with. Right? Nominee director have to look after the agreement, whether the assisted company is doing right, whether the condition which was given by financial institution are compiled by this assisted company, right? So let's go and read what is the law saying. The main objective of nominee director are to ensure that the borrower company compile with all the legal requirements under various corporate law. Okay, nominee director also serve the interest of public policy, sound public policy. That was a very short section. Okay, and very important section is section 161 subsection 4, filing of casual vacancy by board. Okay, I hope you know the meaning of casual vacancy. Actually, it's a vacancy which is occurred by reason of death, right, resignation, disqualification, removal, which is which is not in our hand. Okay, death is not in somebody's hand. Okay, due to some uncertainty, vacancy arise. In that case, that is known as casual vacancy. So tell me, who is going to file that vacancy? Vacancy is to be filled in case of casual vacancy. Let's see the manner of filing of casual vacancy. Okay, if the article is specifying, if article specifies, in that case, casual vacancy to be filled according with the article. Of course, when the article is mentioning everything, right, then the company will go with article of the company. But what if the article is silent? In that case, the casual vacancy is to be filled by board. Okay, first we have to divide it in two parts. First was article of the company. If the article is specifying, in that we'll go for article, whatever it is written in the article. But what if the article is silent? In that case, the casual vacancy is to be filled by whom? Board. Yes, by passing a resolution at board meeting. Okay, but the subsequently approved by a member in immediately next general meeting, right? The vacancy which is appointed by BOD, Board of Director, in board meeting, right? The person who have been appointed, okay, is to be approved by a member, in next general meeting, right? Is this part clear? But what if, there is another question, what if, okay, let me go for a point which is written above, that board is authorized by casual vacancy only if was appointed by company general meeting. Yes, again this point is clear. But what if the casual vacancy is filled by board is again vacated? Okay, again vacated. In that case, board will resulting company vacancy cannot be filled by board again. Is it clear? In this case, board will lose the opportunity to appoint again any other person, right? In this case, members are going to appoint. Okay, members are going to appoint. So first of all, again let's say that manner of filing casual vacancy is if the article is specifying. In that case, we'll go for with article. But what if it is silent? In that case, the board will appoint, but the vacancy which is appointed by any person who is appointed by a board is to be approved by whom? Member in next general meeting. Is this clear? Yes, this is clear. And we know the meaning of casual vacancy, right? Let's go for the section. Let's write it. 161 subsection 4 casual vacancy by board. Okay? Which says that the it shall be filled according with the article. Yes. Okay? If the article, this is article is silent, then the casual vacancy may be filled only by passing a resolution and board meeting. Yes, this is also clear. Appointment means by board shall subsequently approved by member in the immediate next general meeting. Yes, this part is also clear. Terms of office, director shall hold the office only up to the date which director in whose place is appointed and would have held office if he has not been vacated. For example, right, if Mr. X was there for up to 2025, okay, and Mr. X, due to some uncertain reason, for example, he died on 2024, and Mr. Y was appointed, right, on May 2024. So Mr. Y is going to be there for up to 2025, right? He is going to be there. The time period for how many time, the time period is going to be like the Mr. X, the same time periods to be given to Mr. Y, right? Is this part clear? Yes, this part is clear. So what we have covered, 161 additional director, right? 1612 is of alternative director, 1613 is of nominee director, 1614 is of casual vacancy. Is this part cleared, everybody? Let's go for section 169, which says the removal of director by the shareholder. Let's read it again. Section 169 says about the removal of directors by shareholders. Okay, let's read it. What I said from the beginning, I'm saying that the members are having, shareholders are the members of the company. Okay, so what I'm saying that the members are having the right to appoint the director, and the members are also having the right to remove the directors, right? So the company may by ordinary resolution remove director before expiry of period of his office. Yes, whether he is additional director, whether he is rotational director, non-rotational director, if it is filled by casual vacancy, right, alternative director, so on, so many directors, whatever the reason directors are, but there are some exceptional in this case. Okay, so let's read out again. Whether the additional director whether that is additional director, non-rotational director, additional director, again additionally this is rotational director, ठीक है, or filed any casual vacancy, alternative director, nominee director, this is nominee director, director in Indian resident, do you remember this section? Okay, independent director again, or small shareholder director, or any other director, right? Whatever the directors are, the member of the company are having power to remove them. Okay, but before that they have to do something. The special notice is required for the procedure for removal of director. Okay, special notice is to be given to company not earlier than 3 months. What are they saying? Not earlier than 3 months. Okay, before the date of general meeting. Before the date of general meeting. Is this part clear? But not less 14 days before general meeting. Do you remember this 14 days was also in some section 60, 160, or what was that? Do you remember? Try to relate everything. Okay, this is how we are going to relate, and we are going to remember everything. Okay, it's very hard to keep everything here, so please, very big thing is we have to relate each and every section. Okay, so special notice is to be given to the company not earlier than 3 months before the general meeting is going to held, not later, at least it should be given before 14 days. Okay, before general meeting. In short term, we can simply say that the special notice is to be given before 14 days of general meeting. Okay, and it should be signed by member not less than 1% of voting power, 1% of total voting power, or paid up share capital of 5 lakh. Is this clear? Whichever is lower, 1% of voting power, right, or paid up share capital of 5 lakh, whichever is lower. Okay, so it should be signed by at least this criteria. Okay, any of them, whichever is lower, which comes lower. Okay, first of all, opportunity of being heard is given to that director. Okay, director shall have right to make the written representation against his removal. Okay, and he may request the company to send a written representation to every member of the company. Okay, the company have to give notice to every member at least 7 days before the general meeting. Again, do you remember this thing was also written in some section under section 160? Do you remember? Same thing, right? 14 days, then 7 days, right? So the company have to give notice to every member, okay, at least 7 days before the general meeting of the company. Director that cannot be removed. Now this is the main thing, this could be asked in MCQ even, right? Director that cannot be removed under section 169 are if director appointed by tribunal, okay, if appointed by proportional representation 163, right? Yes, or nominee director 161 subsection 3, okay, if it is appointed by tribunal under section 242, okay, if appointed by proportional representation 163 and appointed by financial institution, they are known as nominee directors. Okay, 1613. Is this part clear, everybody? Okay, this part is clear. So this was of removal of directors by shareholder. Okay. Now let's go for the next section. This is also important section. Register of director and key managerial person and their shareholding. Now what are the content of register? Actually, register shall contain such particular detail of security held by whom? Directors, right? Key managerial person. Okay. And what are the content actually written in the register? Okay, well, we'll go and read it. Which would be of course DIN, okay, PAN number, definitely, present name, father's name, mother's name, spouse, birth, date of birth, residential address, nationality, occupation, date of appointment, reappointment or cessation. Okay, these are some particulars which I have mentioned here. There are many more. Okay, I have given I have written here to just to give some example, and you should have some hint what are actually written in the content of register. Okay. Place of keeping the register shall kept, definitely the register at register office of the company. Is this part clear? Yes, this part is clear. And filing of, please focus on this point what I am going to say. Filing of return with registrar. Return shall be filed within 30 days of appointment of every director and key managerial person. The form is Form DIR 12 and it is to be filled within 30 days of appointment of director and key managerial person. Now my question comes, do you remember this form? Form DIR 12 was also filled somewhere. Do you remember? And it was filled in case of section. Now you are going to tell me the section. I'll tell you the name, okay? It is to be filled in case of resignation of director. Same time limit was there, 30 days, and intimation was done by company, director nahi, company to registrar. Okay, now you have to tell me the section. Okay, वैसे देख लिया होगा but कोई नहीं. Now we'll go for section 171, where right of member to inspect the register of directors and key managerial person and their shareholding. Okay, every member shall open for inspection. They have actually right. Every member have right for inspection of register of director and key managerial person. Okay, shall open for inspection. Who can? Member shall open for inspection such only during business hours. Okay, is this clear? Yes. Member shall have right to take extract from the copies. Okay. These topics are also related to direct taxation. Do you remember something? Have you ever read something related to search and seizure and all? If you know, comment below. Okay. Next, extract shall be provided to such member within 30 days. From which date? From the date when the member have actually asked, right? Okay, so this is what the right of member under section 171 to inspect the register of director and key managerial person and their shareholding. And today's last section is section 172, punishment for the contravention of chapter 11, which says every director of the company who is in default shall be punishable with fine shall not be less than 50,000 and maximum which should be up to rupees 5 lakh. Is this part clear, everybody? So what we have covered in this video was additional director 161 subsection 1, alternative director 161 subsection 2, then nominee director 161 subsection 3, casual vacancy 161 section 4. Okay, 169 removal of what? Directors by whom? Right? Shareholders means member. And what were the limit? 1% of voting power, right? And paid up share capital of 5 lakh, whichever is lower. The members are having right to remove any director except 3: tribunal, nominee and proportional representation. Please remember the section with them. Okay, you have to quote section with them. Okay, now what were the last 3 topics? 171 were register of director and key manager person and their shareholding, and what were the content inside it, where are the register kept? In the register office of the company again, and the company have to inform if the changes, which means changes means appointment of director or key manager person is done. In that case, within 30 days the intimation is to be sent by company to the registrar in form number DIR 12. Is it clear? DIR 12 was also filled in case of resignation of director. Section you have to comment below. Okay, now 171 was of right of member to inspect of register of directors and key manager person and shareholding, and last was of 172 was of punishment, which was of which is not going to be less than 50,000, maximum up to 5 lakh. Is this part clear? So what you have to do, guys, this chapter is actually completed. We'll go for meeting of board and its power. Okay, so next chapter is going to be this, and hope you're doing your revision regularly. What you have to do is to keep a written practice, right? What you have to do, another thing was to remember these sections. What you have to do, write it. Okay, write it. You have to make notes in your hand so that you can easily you can write the keywords, right, to remember everything, right? And then at least in the exam, what we can do, that we can easily remember those keywords and make our draft answers, okay? And keep the revisions, okay? If you are thinking once you have done revision for only one time it's enough, no, it's not enough, okay? You have to do it for many times, continuous basis, okay? If for example you're talking to anybody like your friend in this specifically field, then try to have some fun conversation with them, okay? Try to remember, like ask him or her about the particular section, what was the particular section of this topic, and what is the actually condition written in this topic or in this section, or so on, okay? So try to make the conversation and fun, okay? So hope we'll meet in next video.